Good evening and welcome to the special meeting of the Livonia Public Schools Board of Education for Monday night, December 1st. I'm Crystal Frank. Our president, President Bradford, is not here tonight, so I will be presiding over this meeting. Mrs. Acosta, will you take the roll, please?
Yes. Mrs. Burton. Here. Mrs. Frank.
Here.
Mrs. Jarvis is absent. Mr. Johnson.
Here.
Mr. McFarland.
Here.
Mrs. Acosta is here. President Bradford is absent.
Thank you. We don't have any audience communication. There is no blue slips. No one has any blue slips. So we are going to consider the consideration of 31AA funding resolution. May I have a motion, please?
Mrs. Frank.
Mrs. Burton.
Move that the Board of Education of the Livonia Public Schools School District adopt the attached resolution regarding 31AA funding from the state of Michigan.
Support.
Okay, we have a motion by Mrs. Burton, supported by Mrs. Acosta. Mrs. Oquist, are you going to take this?
Yes.
Okay, thank you.
Thanks so much, Vice President Frank. I am bringing to you this evening a follow-up resolution to that which we discussed just under 2 weeks ago. We have been discussing 31AA funding, which is funding for school safety and security and mental health in schools. This year, the legislature added caveats to this funding that would be required to have agreement of a Board of Education and the district in order to receive those dollars. We found the caveats to be very egregious and concerning for many reasons, but the primary reason was it would require us to waive privilege, attorney-client privilege on behalf of our staff and ourselves and the district. We have discussed this at length in prior meetings, if you would like to review those prior meetings. But what we have this evening is, as you know, part of the resolution that the board previously passed included two main portions. One was that the district was not going to be opting in to the funding because of the requirements that were attached to it. The second piece of that was the board giving permission for the district to join the lawsuit against the state, the Michigan Department of Education, the governor, and the state superintendent in regard to these funding requirements, and also for me to join personally as an individual and as a representative of the district. So both Livonia Public Schools and I are considered plaintiffs for the lawsuit about this legislation. So far, we have made progress in that legal action, in that there has been a decision made by all parties involved to extend the deadline from November 30th to December 4th at midnight for districts to opt in to the funding, the 31AA funding. There is an important mechanism in this opt-in clause that has been agreed to, again, by all parties involved in this litigation, that districts may also opt back out of the funding if we do not prevail in our legal action at either the federal or the state level, or if the governor or the legislature on their own makes the determination, or the MDE, to remove the requirement to waive privilege as a requirement for receiving the funding, or if it is found to be unconstitutional. So what I would like to recommend to the board is that we pass an updated resolution, which is before you this evening and is also available for anyone in the community to review on Board Book under our special meeting for 5:15 this evening. And this resolution, which I will read in just a moment, essentially says that we are taking advantage of the opportunity to potentially opt into the funding. So we are going to reserve our right to opt into the funding by opting in by December 4th. And we will do so once we have the board's approval of this motion after you've considered it. And we also have the ability to rescind opting in by December 30th at 11:59 p.m. if we do not prevail in the lawsuit or changes are not made regarding the requirement to waive privilege. So it really gives us the opportunity to, again, reserve our right to receive this funding as a district, and also the ability to rescind during that period of time if those aforementioned pieces are not met. So my recommendation would be that we consider and approve this resolution this evening so that we do not lose the opportunity to opt into funding, but we also have the opportunity to opt out. And what this resolution does is it gives me the ability to do that without having to call the board back into session to make a new resolution to rescind. So, Vice President Frank, may I read the resolution at this time?
Please do.
Livonia Public Schools, Livonia, Michigan, the district. A special meeting of the Board of Education of the district, the board, was held in the boardroom within the boundaries of the district on the first day of December 2025 at 5:15 p.m., the meeting. The meeting was called to order by Crystal Frank, Vice President. It lists those members who are present and absent. And we will fill in the members who made the motion and the support. Whereas, number one, Public Act 15 of 2025 amends State School Aid Act, Section 31AA, MCL 388.1631AA, to allocate funding for fiscal year 2025-2026 to support school safety and student mental health initiatives, as well as to provide certain competitive grant funding, otherwise known as 31AA funding. 2, to receive 31AA funding, the district must agree to receive the funding in the form and manner established by the Michigan Department of Education and either formally opt in or seek a competitive grant. And 3, as a condition of receiving either type of 31AA funding, the district must agree in advance that in the event of a mass casualty event, as defined in MCL 388.1631AA, 1, the district will be subject to and comply with a comprehensive investigation following such an event, and 2, the district will waive privilege that may otherwise protect related information from disclosure. And litigation challenging the legality and enforceability of the privilege waiver requirement is currently pending. And the opt-in deadline for 31AA funding is currently December 4th, 2025 at 11:59 p.m., and it may be subject to further extension, the opt-in deadline, and the litigation parties have stipulated that a district may later rescind its opt-in by providing notice to MDE no later than December 30th, 2025 at 11:59 p.m., as may be subject to further extension, the rescission deadline, in the form and manner established by MDE. And the board has been fully advised of the legal and practical implications of the privilege waiver requirement, including its potential effect on attorney-client privilege and other applicable privileges. And the board desires to preserve the district's eligibility for 31AA funding while avoiding any present waiver of privilege and while allowing time for the courts to determine the legality and enforceability of the privilege waiver requirement. Now, therefore, be it resolved that the board hereby authorizes the superintendent of schools or designee to submit the district's opt-in form to MDE on or before the opt-in deadline solely for the purpose of preserving the district's eligibility for 31AA funding and only on a conditional basis, as provided in this resolution. Submission of the opt-in form shall not constitute a present waiver of the attorney-client privilege or any other privilege. 2, the district's conditional opt-in shall be automatically rescinded without further action of the board unless on or before the rescission deadline, A, the legislature removes, substantially amends, or otherwise eliminates the privilege waiver requirement such that acceptance of 31AA funding would not require waiver of attorney-client privilege or any other applicable privilege, or B, a court of competent jurisdiction rules that the privilege waiver requirement is unlawful, unenforceable, or otherwise not applicable to the district, if neither A nor B occurs by the recension deadline, the superintendent of schools or designee shall notify MDE in the form and manner required by MDE and no later than the recension deadline that the district's opt-in is rescinded. 3, if the privilege waiver requirement remains in effect and enforceable as of the recension deadline, the superintendent of schools or designee shall have no authority or obligation to accept 31AA funding. 4, nothing in this resolution shall be construed as a waiver of attorney-client privilege or any other applicable privilege. 5, the district's participation in the opt-in or rescission process shall not be construed as a waiver of the board or the district's right to challenge the legality or enforceability of any condition imposed by MCL 388.1631AA or related administrative guidance. 6, if after the rescission deadline, the privilege waiver requirement is removed, amended, or invalidated, the board may take further action as it deems appropriate to pursue 31AA funding consistent with applicable law. 7, this resolution does not apply to any mass casualty event occurring prior to the opt-in deadline. 8, all resolutions and parts of resolutions insofar as they conflict with the provisions of this resolution B and the same are hereby rescinded. So the board would now consider, discuss, and vote on the resolution. We will mark those in support and those opposed and determine if the resolution is declared adopted.
Thank you so much. Just a note for the public, Liz Jarvis is here, so we will mark her as attending. Thank you. Any comments or questions? I know that we probably have a lot, but who wants to start with any comments or questions? Or does anybody have anything, or are we going to just go ahead and vote? Mr. Johnson.
Thank you. Thank you, Vice President Frank. A couple of questions, and maybe I'm reading the resolution wrong. In paragraph 6 of the whereas, it says the litigation parties have stipulated that a district may later rescind its opt-in by providing notice to MDE no later than December 30th, 2025 at 11:59, and is subject to further extension in the form and manner established. But then in the therefore, under 2, it says the district's conditional opt-in shall be automatically rescinded without further action of the board unless on or before the rescission date certain things occur.
Yes,
Does that simply mean that you have the authority without the board's action to file the rescission?
That's correct.
Okay,
It is, and so at the end where it says, the superintendent of schools shall notify MDE in the form and manner required, so on and so forth, that it has been rescinded. It simply, what we were looking for from our attorney was a resolution that would not require the board to reconvene over the holiday break when folks are generally out of town, and that would not impact our ability to do so by December 30th. So you have it exactly correct.
okay, so the resolution gives you the authority without further action of the board if A and B don't occur to go ahead and file our rescission of the opt-in.
Yes.
Okay,
And it would be my intent that I would certainly notify you and confirm
Sure.
that everyone is in agreement with that. But also, I believe, because we have had extensive discussion both at study session and at the special meeting, that I believe we're all in agreement that if the waiver requirement, waiver of privilege requirement is present in any form, that we would then rescind and not agree to that.
okay. Understanding that provision, I would be in favor of this resolution.
Any other comments or questions? I know we've had a long time to kind of think about it. Mrs. Burton.
I am also fully in support of this resolution. Our our number one enormous concern was the waiver of attorney-client privilege and any other related privileges that we have, not only for ourselves, but for all of our staff and all of those involved in Livonia Public Schools, students, parents, et cetera. We made it very clear that that was not acceptable to us. So if we are making legal progress right now, and basically this just buys us time, our district and all districts in the state of Michigan, it buys us time while this is going through the courts quickly, but it buys us time to say we will opt in and we will accept these funds as long as that privilege is not sold, basically, for that amount of money. So I am fully in support of this, and I thank you, Mrs. Oquist, very much for the hours and days and now weeks that you have worked on this on behalf of the district and all kids and all families in the state of Michigan.
Thank you, Mrs. Burton.
Anything else?
Yeah, I think really the best way is to say we're reserving our rights
Yes.
to the funding. And
Right.
that was what we thought was a significant step forward in the legal process. Had we
Right.
not gone through that process, this would not have existed.
Right.
So even at that note, we believe it was absolutely appropriate to move forward with legal action in this matter. And it really reserves the right to funding. It does not take us out of that process. And it gives, as you said, the courts a little bit more time to act without us being in a place where we can't rescind.
Mr. Johnson?
Just one more question, and it's sort of tangential. I thought I read something that the court was supposed to issue some ruling by, I think this Thursday, the 4th. Am I correct on that?
They were, and now that this has been agreed to by the parties, it has now been pushed back to the 10th, 11th, and if necessary, the 12th. That's both in state and federal court. And both judges at both levels have agreed to render their decisions by December 19th.
Oh, good.
So we will next be in court on the 10th and the 11th.
Okay, thank you.
Yes.
Anything else? Mrs. Oquist, these monies that are attached to this, they will not be dispersed in that time period, right? We will not be receiving funding until, I thought I read that it's later anyway, that we're not getting money until later. Is that correct?
That's a great question because it's pretty close.
Okay, okay.
So we have been advised to wait as close to December 30th as possible to
Okay.
allow the court, unless we prevail in court by the one or both decisions on the 19th. But in case there are appeals or anything else, we have been encouraged to wait to as close as possible, but to perhaps not wait until the 30th because as the MDE and they work through their mechanism to pay out these dollars, it may indeed get paid out, in which case we would not have to send a check back, so to speak, but they would withhold that same amount of funding in a later payment. So it wouldn't be awful if that happened.
Yeah.
We would certainly go through the process. I believe they would like to avoid that, as would we, having it paid out if we intend to rescind. So I will certainly, if we do not have a clear legal determination by the 19th, we'll be back in touch with the board by the 28th so that we can determine on the 29th how we want to proceed. But they have asked that we consider not waiting until the 30th because in all likelihood, it would hit our account by that
Yes,
time
okay.
since they're leaving as well for a
Yeah.
few days.
Okay, okay, that makes sense. Mrs. Burton?
Mrs. Oquist, in this resolution and in other conversations, we've said that if either the state or the federal court
Yes.
rules in our favor,
Yes.
then we're fine. And that
Yes.
is true because the state, obviously, we would have jurisdiction over us, but that federal has jurisdiction over the state. So even if federal says this is unconstitutional and the state still holds their ground, it still cannot be carried out in the state of Michigan. Is that correct?
Yes, there were different constitutional arguments made at the state level and the federal level. And so if either of them prevail, then it would be removed.
Okay, thank
Yeah.
you.
Thank you. And I think it's important to say that this all has come about through some wording in this legislation that has not been clear to all of us. And so I think that's been frustrating for school districts all across the state to have to spend so much time on this whenever it could have been clearer and it could have been something that districts understood and districts were able to either opt in or opt out of. But the amount of legal wrangling that is going on with this is certainly disappointing in terms of our legislature that has allowed this to continue to happen. And so it puts school districts and Board of Education in an untenuous situation to have to figure this out and navigate this. But we will do so, and we will try to get do the best for our students that are entrusted to us. If there are no other questions or comments, we'll take a vote on this. Mrs. Acosta, will you take a vote, please?
Mrs. Burton,
Yes.
Mrs. Frank,
Yes.
Mrs. Jarvis,
Yes.
Mr. Johnson,
Yes.
Mr. McFarland,
Yes.
Mrs. Acosta says yes.
The resolution passes. Thank you. If there are no other questions or comments, then we will adjourn this meeting and head to our study session. Thank you so much for tuning in.